Hello, and welcome to episode 20 of the Legal Scoop and the Daily Grind. This is our collaboration extravaganza that we wanted to do to celebrate getting to 20 episodes. So, congrats, Melanie.
You too, thank you.
I'm Brendan Shannon, and I host the Legal Scoop, which is a webinar series where we discuss recent wins by our attorneys or our staff here at LOMAD and how they can help you handle your files. Melanie, why don't you go ahead and introduce yourself?
Yes, I'm Melanie Daly, and I host the Daily Grind, where we discuss workers' compensation issues over hot cups of coffee.
So today, I'm not prepared because I didn't come with ice cream, so I'm not as on brand as Melanie is. But today, we're gonna, for this joint episode, talk about some things that sort of grind our gears, things that are just really annoying in comp, and ways around them or ways to approach them. One thing that I think everyone watching this video could agree on is that when you're on the side of the carrier or the self-insured employer, there's going to be a lot of these topics. So we'll try and be brief and quick on them. The first one that I have is frequently you'll see out-of-network diagnostics, and then the adjuster will file a CAPO-1B saying this is an out-of-network diagnostic study, whether it be an EMG or MRI, anything like that. Now, a lot of judges, what they do is they'll find the CAPO-1B in favor of the provider, but at the network rate. So basically, they'll say, yeah, it's out of network, but it's going to be paid just at the contracted rate. So whatever you contracted with your in-network provider, you'll just pay that rate to this out-of-network provider. That is completely wrong. So as long as we provided proper notice to the claimant and the claimant's providers, then the CAPO-1B needs to be found for the carrier in its entirety. And that makes sense. If you were contracting with a certain provider, you shouldn't have to pay a provider that you didn't contract with just at the rate that you contracted with the other provider. So the key there is just make sure that you provide notice to the claimant and provide notice to the claimant's providers. There are services that will basically just send out a mass notice to all providers in the area or for that specialty, and that's one way to do it. And then make sure when you file the CAPO-1B that you attach all that proof, because then it makes it easy to just say, Judge, nope, you're wrong. It needs to be CAPO-1B found for the carrier outright. Next up, and I think Melanie's going to have a lot to say on this one, there's a lot of issues with burdens of proof in comp and with presumptions being treated as though like that's the proof that they need to establish this case. So what were you going to say about that, Melanie?
Yeah, it just seems like the presumptions of Section 21, they're supposed to just give the claimant a presumption that we have to overcome. And it just seems like it's kind of shifting more toward us needing to prove that it didn't happen instead of the claimant. The claimant basically, it seems to be relieved of that burden of proof, and it's always the claimant's burden of proof.
Yeah.
The presumptions of 21 should not be a substitute for the claimant meeting that burden, and a lot of times it is.
Yeah, and I think with that, it doesn't relieve the claimant of proving that an accident actually occurred, which triggers a credibility assessment. And I mean, a lot of the times you can prove that there's lack of credibility. I mean, if you've got different reported accidents from, between the medical and the C3, inconsistent testimony, that's supposed to factor into that consideration. And I think a lot of the times we're seeing that it's not being properly considered, which is why, especially in a case like that, like we would always recommend an appeal if it was established, because when you appeal establishment in a controverted case, the board's going to review it completely anew as though the judge didn't consider it, or at least they're supposed to. And when you do that, you'll be able to get them to look at it a little bit more objectively, like, look at these inconsistencies. It's not credible. You can't just find that this accident occurred, and in which case the presumption does not apply. The other thing I'm sure you've noticed, Melanie, is that a lot of times they just try and shift certain other burdens to us, which like causal relationship, which is one of the main elements of a workers' compensation claim. If the claimant does not meet that burden of producing medical evidence on causal relationship, the claim can't be established. Period. It's their burden. We don't need to produce an IME.
And
Do
this
you
is,
see that?
yes, this is especially frustrating when we request a HIPAA and there's a direction for a HIPAA for prior records treatment, and that's just never complied with, and it's just lost. And nobody really gives that any consideration when it is the carrier's right to investigate the claimant's prior injuries. Because as we know, claimants are not always honest, and if they have had a prior injury, um, we have the right to investigate that. And a lot of times we try to get the direction. Sometimes law judges will only allow the direction of the C 3.3, which is limited.
It's
But
useless.
yeah, it really is useless. So we always try to go for the HIPAA, but even then, I mean, we email the claimant and no response, and then that direction just doesn't seem to matter when it comes to establishing the case.
Yeah, I think some ways around this too is like the regulation for controversial cases requires that it be determined whether there were prior comp claims at the pre-hearing conference. So we can just throw that, you know, on the record at a hearing and insist that it be investigated. And, a lot of the times a judge will investigate it. The other thing is that grounds for requesting an IME extension would be if like prior records can't be obtained. So if like the claimant's not producing the HIPAA that we're requesting or the medical provider list that we need, we can continue to file an extension request, which would delay the case because I mean we're not getting the HIPAA that was directed. And then I think another approach that would be that we could also just ask that, okay, the HIPAA's not been produced. In this case, the claimant should be directed to produce, the initial hospital records or anything like that. The only issue there is that then it's like completely left to the claimant to produce what we maybe don't know exists. So I agree. That is one of the most frustrating things. And especially when I mean, I don't know, Melanie, do you agree that like a lot of times in a contrary case, you don't want to get an IME?
Correct, because it just gives we feel the claimant another opportunity to provide just an additional history of the incident, and sometimes they really can work against us.
Yeah. Well, and a doctor is going to hear a description, and if the description is consistent with what the clinic's been reporting, they're going to be more inclined to find causal relationship just based on what's reported to them. They're not doing any fact finding. They're not taking testimony or anything like that.
Right.
So I think that's something to be open to, with your files is as adjusters is, while it can seem a little scary, sometimes it's worth the risk of not obtaining an IME in a controversial case because, again, it's not our burden. And
Right.
I think we're very good at explaining to the judge and convincing the judge that it's not our burden.
Exactly, and that's what a lot of claimants' attorneys will argue. Well, there's no contrary medical; they
Hmm.
didn't get an IME, but that's not the standard. We're not required to get an IME. It's the claimant's burden based on the medical evidence to establish that causal relationship.
I think going along with this one thing that really grinds my gears is there is third department case law in Fox v. Altmar Parish from like 2 years ago, I think, that we've talked about on the Legal Scoop. And basically, the idea is that if there's been prior injury, it's actually not really limited to only if there's been a prior injury, but doctors need to review prior relevant treatment records, whether that's prior to when they started seeing the claimant or prior to the actual date of accident. So if there was an injury before the date of accident or an issue with an overlapping site before the date of accident, the doctor not only needs to know about that, but they need to actually consider the medical. If they're going to issue an opinion on causal relationship, I think it's sort of self-explanatory. Like, yeah, like how could you not look at prior medical if you're going to find causal relationship, especially for an unwitnessed accident? But I don't know if you've seen this, Melanie, but that case law is just ignored. It's
It
completely
is.
ignored.
It really is. And we'll take the testimony of these doctors and ask them, would it be necessary to review prior records? And they say no, which of course doesn't help, but of course it would be. I mean, there's no way it could not be relevant to find causal relationship if you haven't reviewed prior records that do exist. And
Right.
that really is ignored. That's where the presumption comes in. And it just seems like they rely so heavily on that presumption that it's impossible sometimes to overcome it.
Yeah, I mean, I actually recently had to do research on this issue, and I looked to see how many cases at the board panel level have cited the Fox case, and it was less than 10.
Wow.
And the ones that did, primarily, I think all of them just distinguished it. And I think this is an area of law that needs to be expanded upon and that we need to continue to pursue, because the third department decision in Fox is unambiguous on what is required of these doctors when issuing causal relationship opinions, as when there's prior overlapping treatment, or injuries, or even like you got a case where someone got injured in January and first saw this doctor who was issuing a causal relationship opinion in June. That doctor needs to have reviewed the ER report and needs to have
Yes.
reviewed the imaging. It should be self-explanatory, and I think this is another thing that we should be focusing on in our cases when trying to push the issue of, the burden of proof on causal relationship.
And another thing that does frustrate us, that goes along with that burden of proof and the claimant's requirement to fill out a C3. A lot of times they either will not complete one or they will provide an incomplete one that doesn't answer the question about prior injuries, doesn't answer the question whether it was a workers' comp injury, does not provide the medical information required for us to investigate those prior injuries. And that sometimes can go ignored also, and that's just delaying our ability to defend the file on an expedited track. And it frustrates the purpose, but it doesn't also seems to be ignored, just like the Fox case.
Yeah, I think that's a great one. And I think probably the last one that I have, I don't know if you have any more, Melanie. Um, One that kind of goes along with a lot of what we've been talking about today is, a lot of times the IME will be adopted without any question if the IME finds something adverse to the employer or the carrier. However, if the IME finds something that's adverse to the claimant, there has to be all this, litigation and fact finding on the issue, depositions, arguments. Um, we would take the position that, if just because an IME finds something adverse to us, that doesn't preclude further litigation on the issue. For example, under the recent Lasley case, from the Court of Appeals, we're entitled to cross-examination of the treating doctor, and that's regardless of whether the IME, finds something not in our favor, because sometimes an IME finds something not in favor of, the carrier or the employer in error. I mean, sometimes the doctors make mistakes. So I think that's something too that we should be on the lookout for, and that, if you're an adjuster watching this, or you're a self-insured employer and you're watching this, and you have a case where you're like, oh no, this IME, found something that's not favorable to us. However, oh my gosh, like the IME did this wrong or didn't follow the guidelines, whatever, it's worth looking into.
Absolutely. And one last one that I have kind of goes along with the the cost relationship and the burden of proof, is the issue of apportionment. We all know that if it's not a prior workers' compensation claim, then we have to wait until permanency to apportion. But there are some cases that are just frustrating when the claimant clearly has a pre-existing um, severe osteoarthritis in a joint, and he would have needed a total replacement anyway. But it just seems unfair that he'll feel a pop. He's lifting something, feels a pop, and that entire medical history is on this claim. That just goes in part to our need to request and investigate prior records in order to try to at least dispute causal relationship or find some sort of apportionment, or the fact that he would have needed that surgery anyway. But that goes along with the claimant, not complying with prior treatment or denying prior treatment when it clearly exists, or not remembering prior treatment. So
Hmm.
that's another one that grinds our gears.
Yeah. Well, and I think, like our recommendation there to any adjuster would be always get an ISO and
Mm-hmm.
get updated ISOs too,
Yeah.
because sometimes they have updates or there's subsequent accidents or anything like that, and that can provide us with, a means for getting more information on these potentially prior injuries. The other thing that sometimes, can be useful, for investigation purposes as far as prior treatment are medical campuses. Um, if you have a HIPAA, where they'll look into whether the claimant's treated, with certain relevant providers like a chiropractor or anything like that in the area.
Mm-hmm.
So it's just something to consider. So I think this wraps up our 20th episode extravaganza. You can find all our videos on YouTube, so we ask that you please subscribe. And I think next month we'll both be back with our individual episodes, and maybe we'll do this again on the 50th. What do you
Sure.
say?
Sounds great to me. Thank you for watching, everybody. We'll see you next time.